I was standing down.
Oh,
there.
that's it. Okay, that's good.
Today we're having a press conference about the new law, the Safety Act. My name is Paul McKinley, PAUL-MCKINLEY. I'm an ex-offender organization, and we oppose the Safety Act because it's not safe. We also would like to bring the chief up. We also have Tom DeVore that's going to come up, and they're going to have comments, and then I will close it out. Chief, would you like to come up first?
Sure. Good morning, everyone. How are you doing? All right, I'm just here to kind of emphasize one component of the Safety Act that's really important.
Can you start with your name and your title?
Sure. I am Chief of Small Suburban Department here, David Shepard, currently running for the 36th District State Representative spot. Right now, in the Safety Act, there's a component in there that states that people charged with second-degree murder can be released. I don't understand how the parties got together and decided that this was a good idea. That's an unsafe act. So this means, and understand me, you are charged with a crime. We arrest you, we bring you to our station, and we release you. Another component is kidnapping. So you kidnap a person, we charge you with the crime, we release you to return right back to your neighborhood to kidnap a person again. How is this safe? 36 people currently now that has been charged with murder that's out on bail, that has been recharged with some new crime of violence. The Safety Act is an unsafe act, and we must do something to change it. Remember, second-degree murder, charged, released, returned back to your communities. How is this safe? I don't understand. Thank you for your time.
Thank you very much. The next person will be Tom DeVore.
Thank you, sir. Thank you, everybody. I'm Tom DeVore. I'm the current Attorney General candidate for the state of Illinois. You know, when Mr. Shepard said, how does this happen? Before talking about some of the nuances of this act, I can explain to Mr. Shepard how this happened. House bill that we are dealing with here, what many people don't know, is that it started off in, I think, February of 2019 as a pretty straightforward House bill that went through all three readings and passed the House in April of 2019. It had to do with the elections and the information that would be given to those who are incarcerated that were getting out. That was the essence of the bill. And from April of 2019 until January 10th of 2021, almost 2 years, that bill sat dead in assignments. And the Democrats, as usual, gut and replaced that bill right before the new General Assembly was supposed to take over. And they completely replaced it with what we now know as the Safety Act. It didn't go back, obviously, doesn't have to go back to the House to be read 3 times again. And not only did they do that, they did it after it had already been read twice in the Senate. So they shoved this whole amendment in there and pushed it through at the last minute. The irony is that our new General Assembly was going to take over in about an hour, and they didn't have the 60 votes they needed in the House. And miraculously, after some amount of conversation and numerous calls for the vote to be closed, they get their 60th vote. The public didn't know about that bill for a lot of reasons, but primarily is because it was in front of the General Assembly for a couple of days. That's how it got there. That process is an absolute abuse of our due process rights as people to be allowed to participate in our government. If I'm Attorney General, I will do everything I can to stop those kind of games being played in our legislature. Now, as to the Safety Act itself, the governor, I read what he writes painfully, and he's saying there's no such thing as a non-detainable offense. He's playing games with words because it's true, non-detainable does not exist in the statute. What the statute does is it enumerates types of crimes that detention is possible. It lists them in the statute. You can be detained for a variety of things. By deduction, basic human analysis, anything that is not enumerated, you cannot detain. That is non-detainable. That's where that word comes from. What is non-detainable, if you go through it? Depends upon the criminal code. Offenses that are forcible felonies that you cannot get probation for is a big category of things that you can be detained for. Second-degree murder is one of those criminal offenses that you cannot automatically be detained because of that offense. Kidnapping is another one. Robbery is another one. These aren't just my words. These are the words of overwhelmingly most states' attorneys who have analyzed this bill across the state, Democrat and Republican. There's a catch-all phrase that says, well, what if they're a high flight risk? We can detain them then. The burden of proving that will be significant. It's a catch-all that is not going to be applicable according to most states' attorneys that I talk to. Another one is aggravated DUI that can include death of people. Mothers Against Drug Drivers ought to be outraged that they may not potentially be able to detain those who commit those offenses. That's what this bill is about. Another thing that makes it even worse is that you deal with, well, what happens once someone is released because they can't be detained, but they still have to come back to court? You no longer can just issue an arrest warrant if someone doesn't appear for their court date. That process is gone. It becomes more civil in nature with what's called a rule to show cause. A rule to show cause is a document that is filed by the state. The court will issue the order. Then that order has to be taken and served upon that defendant within 48 hours of the hearing. And if they're not served, they don't have to appear. If they're served and then they don't appear, then you could maybe get a body attachment against them. That process, we do it in the civil courts all the time. It's very complicated. It's very cumbersome. The criminal system is not going to be able to use that. Those are the concerns. There's a bunch of others. I don't have time to go through them all today. But ultimately what this comes down to, the reason we are having this conversation today is because this bill was crammed through at the last minute by special interest groups without our legislature, both Democrat and Republican, having ample opportunity to review it and for the public to see it. And now that these realities are coming to light, the legislature's paralyzed and they don't want to address it. They should address it. They should absolutely go back into session. They should deal with this, fix what needs to be fixed. There's good provisions in that bill that were absolutely appropriate. This is one that they completely missed, and they need to take care of it. Thank you.
The reason why our ex-offender organization has an issue with this bill, because we know in the black community there's a lot of revenge shooters, people who are revenging for other people who have been got shot. To release people for shooting people, for kidnapping people, and allowing these people back in the neighborhood will cause great harm in our community. And our only thing is that this bill comes in effect at the beginning of next year, and that by this bill coming into effect after the election, that the mayor, that the governor could have stopped this bill, and that Pritzker Raoul could have put an injunction until people that have a better understanding in the community could have even viewed. This bill was put in place without any community input. Originally, they said for non-violent offense. That's what this all started about non-violence offense, people being released on a non-violent. Now they have took it and these violence offense in our community, this will create turmoil, havoc, and chaos in the black community. And we're asking that the Justice Department, we're asking that the President of the United States send the Justice Department to investigate the reason why it was even passed. Because we believe that it was only passed for political reasons. It was only passed for political reasons, for the hyping a liberal agenda that is being forced down the black community as well as the rest of the community. Because these murders in our community people need to have a bond. We're not saying we have a constitution to have a bond, not a ransom bond, but a bond that people can pay for. What is you letting people out of jail without a bond? Why would he come back to court? If you catch a man dead to right on a second-degree murder, dead to right, gun in his hand, or whatever the case may be, what's going to make that man come back to court knowing that he's going to get found guilty? And what's going to make the community not seek revenge on that person that did something in their community? So you got the community that may turn vigilante, and you got the perpetrator that may go back out and do something again. And so we saying in the black community that this was a law that was put in place to keep up chaos, to keep up violence in our community, and to keep our community at odds with each other. And so that's why we asked the Justice Department, and we asked them to investigate Pritzker Raoul for not filing nothing. Pritzker Raoul has not came out and said, and we asked that the press ask Pritzker Raoul, what is he going to do about this law? Don't just ask us, ask the governor, what is he going to do about this law? Ask the states, the people that voted for this, what are they going to do to stop this law before it come into effect at the beginning of next year? With that, we thank everybody, and if there's any questions for any of the candidates, you can ask the questions now.
Tom, let me ask you, okay. It was the black, if I can ask this, Tom.
Yes, sir.
The Black Caucus pushed this through. You know, says we don't want to criminalize poverty. And isn't it true that judges will have the discretion to detain without bond people who are a danger to the community? That's in the statute.
Well, that's in the statute if you actually get to that hearing, Craig. But before you even get to that hearing to make that decision, it has to be a detainable crime. It's a two-step process. If the crime is detainable, then you get to the hearing and the judge can make some decisions about whether they should be detained or not detained, whether there should be conditions. But what people miss in that analysis is that before you even get there, it has to be a crime where the judge actually has the opportunity to have that hearing. The language we've been using, non-detainable, for example, straight kidnapping. The judge never gets to that point because it's not a crime that he has the discretion to determine detainment or not, because the legislature has already said you can't detain for that.
So you can't detain for kidnapping, you can't detain for second-degree murder?
Not unless there is another factor that there's a high likelihood of flight. And if you read the statute, because that's another...
But isn't it danger to the community and high risk of flight?
Once you get to the detainment hearing, but you have to get to that hearing first, and that depends on the type of crime. High likelihood of flight on any crime can get you into that detainment hearing, right? If you allege high likelihood of flight, then you have to go prove it to the judge. So if you have a second-degree murder or a kidnapping, if the state's attorney is not convinced that that particular alleged perpetrator is a high likelihood of flight, they can't even ask the judge for a detainment hearing. That's what the law says. And again, any state's attorney you ask would agree with me.
But you're saying that is the first determining point before you can even go to detention?
What type of crime it is, yes.
What type of crime? Right.
Yes, sir.
So, but it doesn't have to be high risk of flight.
High risk of flight can be applied to any crime, but the state's attorney has to be convinced that they can prove that. And if you read that element, that's where the governor's been trying to say and confuse people, well, the judge can detain for any crime. That's not true, because it has to be, again, if you read the statute on what it takes to show high likelihood of flight, it's a very high burden. And you have to show that they're actually in the process of contemplating it. And you cannot use, well, they haven't showed up to court in the past on other cases. That's not even a factor. Proving high likelihood of flight, Craig, it's a red herring. It's almost never going to happen. And again, if you don't get in front of the judge on a detainable crime, then you don't even have that conversation.
Tom, would you consider simply lowering the proposal to simply lower the bonds to where that makes it more affordable for people that are accused? Would that be something you could support, or do you just see that this no cash bail has to go away?
No, I wouldn't say that. I think there's a lot of merit to the initial conversation of not having bailed, or financial limitations are the sole reason people can't get out, especially for non-violent offenders, right? You won't find anybody across the state, state's attorneys, lawyers, even me, to say if you're a non-violent offender, don't set a bond that you can't financially afford and you sit there. That is not right, okay? But when you add the violence factor into it, that's a problem. And another thing is we have to accept is that when someone posts a bond, one of the reasons that is it encourages them to come back to court and to finish the legal process. That is a financial incentive, because if you don't comply with that condition, among others, you can lose your money. That is an incentive. So when you take that away, I think Paul may have said it, when you eliminate that, it decentivizes people coming back to court. And then the process to get them back into the court system is very complicated, and it's going to just absolutely bog the system down. But I am not opposed to eliminating bail under certain circumstances. I think it makes sense, the cash bail.
What is that process, if I may, to get people back? If they take advantage of no cash and they get out, and they don't show up, what happens?
The state has to go and issue what's called a rule to show cause. That's a civil filing. And what you're saying to the judge is that, hey, we ordered them to be here on this date. They haven't shown up. We need you to issue an order to show cause that the judge is signing, saying you were supposed to be here, you're not here now. And that has to be served upon them, right? You have to have someone, an officer, a process server, go out and physically find them and hand that to them within 48 hours of the hearing. If they are not served, they do not have to appear. If they are served and then they don't appear for that, then the judge can issue a body attachment to say you didn't show up. Now that attachment can go and potentially get that person. The way that's different is if under the current process, if you have a court hearing and you don't show up for that hearing in a criminal matter, the judge can immediately ask for a warrant. Judge can't do that anymore. So that extra step that I just explained to you it's very cumbersome, because I've done it hundreds of times in trying to do debt collection for my clients. It's the same process. It's absolutely not going to work. It's not going to work in bigger municipalities for certain, and in smaller communities it'll still be a problem, because our police officers right now, we have limited resources there, and they're going to have to spend their time going out issuing and serving these orders to show cause. It's not going to work, I can tell you.
So this is all a complicated thing.
Yeah, very complicated.
People looking at home, trying to understand the sort of bottom line. Are you suggesting, based on the way you're explaining it here, that there is going to be, much less accountability for criminal activity across the board because people aren't going to show up to court? I mean, can you summarize what this, in essence, is going to mean for accountability and people being brought to justice?
Accountability is a broad word, so I'll say that as to this particular issue, there is a desire for everyone, the judicial system, those who have been accused of crimes, to bring those to finality, so the system can move slowly or smoothly, and for people know what to expect. I'm saying that this process is going to bog that down, and it's going to drag it out, and the caseloads of unfinalized criminal cases is going to go up significantly. There's no way to get around that whatsoever.
But does that mean that people who commit these crimes are never going to be held to account if they are indeed, guilty of it?
There will be some that will never be held to account. That is true. And again, I can compare that to the civil nature of again, these rules to show cause in civil matters. Many times those will go unresolved, and those types of civil cases can set forever, because getting an order to show cause, getting it served on people that don't want to be found, and then once you serve them, you're not arresting them when you serve them like we can do now. Hey, you didn't come to court, you're arrested. You take them and put them in jail, they go to the judge. You serve them, then if they don't show up, you can go try to arrest them. So adding that whole second step within there is going to delay these cases, and in some circumstances, there will be no resolution to cases. That's true.
Probably have time for one more question if anybody's not.
And let me leave you with this. The state's attorneys that I talk to, the judges that I talk to, one of the things that they are dissatisfied about, and they're not dissatisfied about, hey, let's talk about how we can eliminate some of this bond stuff with nonviolent offenders. They're okay. And that happens in many communities, and some it's not as great, but many it does. Is we're taking all of the discretion of these decisions away from the local judicial system. We're taking it away from the judges, taking it away from the state's attorney, and what we've really done is centralize a lot of this discretion into a statute that was crammed through the legislature in 3 days. That's what we did, and that's what the concerns are. Okay, so if we want to resolve this issue, this legislation can be improved, as we're talking about the cash bail. It can be improved, and that improvement's going to require putting that deference in some fashion with some guidelines back in front of the judges that see these people day to day. They see the criminals in their communities, and they understand their communities. That's where this needs to go, and not have this the centralized discretion on what is even a detainable offense and what's not. That's one of the biggest issues, Craig. Thank you.
And so that'll be pretty much it. And that's this press conference. Thank you very much for coming out.